If you are watching this lecture asynchronously, please take this quiz to start. You can also find this quiz in the Files section on the main page of the GDS website. For those of you watching live, I put the link in the chat window. I'm going to pause the recording for 10 minutes for you to take the quiz, then we will resume. If you're watching a recording, please pause the recording now, take the quiz, and then resume the recording. Part 1, Introduction. As early as 1897, Oliver Wendell Holmes had pointed out, the language of judicial decision is mainly the language of logic, and the logical method and form flatter that longing for certainty and for repose which is in every human mind, but certainly generally is illusion, and repose is not the destiny of man. Behind the logical form lies a judgment as to the relative worth and importance of competing legislative grounds, often an inarticulate and unconscious judgment, it is true, and yet the very root and nerve of the whole proceeding. You can give any conclusion a logical form. Today we are going to talk about critical legal studies, which is a foundational argument for this topic. Although you might not hear many people call their K critical legal studies, it's the basis for many of the critiques you will hear. Today we'll talk about the history of critical legal studies, talk about the strengths of the CLS argument, the weaknesses of CLS as a debate argument, and then I'm going to give you a few ideas for further research. Part 2, History of Critical Legal Studies. This is from Haasnas, 1995. During the past 2 decades, the legal scholars identified with the critical legal studies movement have gained a great deal of notoriety for their unrelenting attacks on traditional liberal legal theory. The modus operandi of these scholars has been to select a specific area of the law and show that because the rules and principles that comprise it are logically incoherent, legal outcomes can always be manipulated by those in power to favor their interests at the expense of the politically subordinated classes. The critics then argued the claim that the law consists of determinate, just rules, which are impartially applied to all, is a ruse employed by the powerful to cause these subordinated classes to view the oppressive legal rulings as the necessary outcomes of an objective system of justice. This renders the oppressed more willing to accept their socially subordinated status. Thus, the critics maintain that the concept of the rule of law is simply a facade used to maintain the socially dominant position of white males in an oppressive and illegitimate capitalist system. In taking this approach, the critics recognize that the law is indeterminate and thus that it necessarily reflects the moral and political values of those empowered to render legal decisions. Their objection is that those who currently wield this power subscribe to the wrong set of values. They wish to change the legal system from one which embodies what they regard as the hierarchical, oppressive values of capitalism to one which embodies the more egalitarian, democratic values that they usually associate with socialism. The critics accept that the law must be provided exclusively by the state, and hence that it must impose one set of values on all members of society. Their contention is that the particular set of values currently being imposed is the wrong one. Okay, now I'd like you to take this opportunity to read the answers to your quiz. You can either click on this Google Docs link, or again, you can go to the file section of the main GDS website and look for answers to Haasnas quiz, and you'll find the answers there. Please do that before resuming this lecture. Okay. Let's talk about CLS in debate. I'm going to share my screen now so you can look at a sample 1NC shell. Part 3, strengths. There's a lot of truth to the argument that the law is indeterminate and that it serves the interests of the elite, usually white males. That That makes it easy to win a link and an impact. Any app that uses the law links. So let's take a look at the impact. The impact is very useful for turning the app case, particularly when the impact is racism, oppression, or structural violence type impacts. It also has a good internal link to war scenarios with the argument that what makes people willing to kill others in the name of the law is the myth that enforcing laws is justifiable without contemplating the ethics of those laws. It's not as strong against environment type arguments, but in those instances, negative teams will have to go for solvency, circumvention type arguments about how the law can always be interpreted in different ways and is constantly subject to changing political whim. This argument is sometimes called blip in time, i.e. Obama put forth a lot of effort to increase the EPA's ability to try and protect the environment, which Trump immediately gutted when he came into office. The law masks how those policies will only happen if they serve the interests of the elites, and we are given false hope by laws that try to solve environmental problems. Alternatives. There are a lot of possible alternatives to CLS, but most of them are quite vulnerable to the permutation. So this one in C uses the trash the law alternative and has good EV on acting locally, like in debate spaces. This alternative is difficult to perm and accesses arguments like fiat bad, i.e. it's a waste of our time to talk about what the United States federal government should do since we don't have any control over that. Card about every instance matters is virtually perfect for the debate. The app creates a vision of the world using the law. The judge can reject that vision and all the untoward assumptions that are included in that world. Part 4, weaknesses. So I'd move the document down so you can see one of the cards in this particular 2AC. Just because the law is somewhat indeterminate doesn't mean it is entirely unpredictable. Many decisions have been upheld time and time again via precedent and the doctrine of stare decisis. Second, absolute determinacy would be bad. It would ensure that the law couldn't adjust to changing conditions, and so things like slavery would have continued to remain legal. Also, it's incredibly non-unique. As with many critiques, the negative always faces the tension of not really solving anything or becoming vulnerable to the permutation. The critique lacks specificity. Presumably, the affirmative will have very specific solvency evidence. To be successful, the negative has to be able to explain how the specific plan will be used in nefarious ways. Different types of asks will be more vulnerable to this critique than others. So, for example, because the treatments app is heavily reliant on the legal system and the EBS app is completely reliant on judicial interpretations of concepts like equal protection, it is quite vulnerable to this critique. An app like Abolish Prisons can use fiat to distance itself from reliance on the law. The 2AC argument that the plan ends funding for prisons is a pretty persuasive argument as to how it would be difficult to circumvent the plan. The alternative has no pragmatic value. Drug addicts will still be drug addicts without access to treatment for addiction. People who are in prison will still be in prison even if we trash the law. The AF can effectively argue that solvency/circumvention arguments aren't 100%. Maybe indeterminacy means that they can't help all addicts, but if they help more than the status quo, then the judge should vote affirmative. anarchy. If we don't rely on the law, then what happens to society? The Haasnas-style arguments are particularly vulnerable to this, although he does provide a substantial amount of arguments in response to this criticism, including a language critique of the word anarchy. This is a particularly salient debate right now, as society at large is discussing abolishing, defunding, or reforming the police. There should be ample evidence on both sides for people willing to supplement their CLS research with evidence from current events. Many of the arguments that are in this particular 2AC we've already discussed, but I think it's worth the time to just take a little bit more of an in-depth look. So here we have the Kelman evidence that CLS just changes who is lionized, recreating the hierarchies they are trying to debunk. So this is the argument that maybe we have certain hierarchies now, but those, if we're going to have any type of law, and remember, CLS doesn't completely reject the law, except for in the extreme versions like the Haasnas version, they keep the law, they just aim to change who benefits from the law, which means it will merely change the hierarchies. It does not completely get rid of the hierarchies. Their goal is to impose a different hierarchy. The Miranda evidence is quite good on the importance of rights as a method of obtaining power for minority groups. And this particular piece of evidence goes through an example of how if you're a white male, your ability to rely on informal norms is pretty high versus someone without that type of privilege is actually helped by the ability to maintain very specific contracts and very specific agreements that they know will be enforced by the courts. The alternative to CLS is a failure. And this is kind of more just the type of argument that says that that really critical legal studies is just a bunch of legal professors sitting around talking about things, much like debate coaches sit around talking about debate theory. But in reality, those theories never get off the ground. They're just lunchroom conversation. This is just another argument about the lack of an alternative to have an appropriate alternative, given that they're just a discourse-based argument. And if you don't change the discourses, then you're unable to actually change the way the system works. This is the argument we talked about before about CLS not having pragmatic value. This is the argument about indeterminacy isn't an absolute question, that even if the law is not 100% determinate, we can make relative guesses about the way in which the law will be interpreted and executed. And in fact, there are many, many, many cases that have been upheld time after time after time after time. And that creates a certain level of predictability with the law, even if all areas of the law don't have that level of predictability, many do. And so the challenge for the negative is to say the indeterminacy that's inherent to the affirmative will spill over into these types of problems versus the affirmative's specificity of their solvency evidence. The Balkan evidence is one of these examples that relies a little bit on pragmatism and kind of leads us down that path toward the anarchy type arguments that, that democracy may not be the perfect system, but it's the best that we've come up with so far. And in this way, if the alternative is no law or indeterminate law, we're better off with indeterminate law. and the McCormick evidence that it just creates a different type of tyrannical majority, which also would increase oppression. This is a good argument to address common critique type arguments of ethical questions or epistemology questions. This Binder 1987 evidence has become true as we recognize that just because that more and more our society is recognizing that just because it's written down and given the status of law doesn't mean that people just are like, oh, okay, that's the law, and even if it's unjust, we can't do anything about it. Which I think that's the case with a lot of these arguments. The better you are at saying, yes, our evidence is from 1987, but things that are happening right now prove that way back in 1987, Bender knew what they were talking about. And here's another piece of evidence from McCormick, and just saying that, you know, the trashing of the law, one case at a time, will only result in, it won't, absent the anarchy alternative, which completely gets rid of the law and the resulting disadvantages, then we're just left with a legal system that is even more indeterminate than the status quo. More evidence on the same argument. This is an answer to the alternative that says that they would spur a movement. It makes arguments about the viability and potential fascist nature of said movements. This is an argument about how, because CLS merely wants to change the values that are imposed by the law, that they are replicating or reifying the same authoritarian structures that they're criticizing. More Miranda evidence about the way that this particular perspective would affect the oppressed groups. And, you know, it's a pretty good line. Although CLS purports to be a radical movement, people of color have not flocked to it because CLS has not paid much attention to minorities and racial questions. Similarly, the disproportionately low grassroots membership and participation in CLS is a cause for concern. Although CLS offers some benefit for minority scholarship, its basic flaw has been the movement's inability to incorporate the authentic experience of minority communities in America. All right. Our final section, part 5, further research. If you would like to research this argument for yourself, I suggest starting with the Haasnas article and the Gable article. You can see those sites now, so you can pause the recording or come back to this recording and find them on Nexus, which is available via the Georgetown Library. Haasnas is particularly good at providing examples that illustrate how the myth of the rule of law has led to many, many atrocities. He gives the type of examples that you can use in debate to contextualize your critique to the affirmative and to explain how the myth of the rule of law leads to a variety of different bad impacts. I particularly like the Gable articles for his discussion of how the law alienates us from the other and puts into motion the creation of distance from our humanity. Our quest as human beings should be self-actualization, and the law inhibits that process and should be rejected. So this concludes our discussion of critical legal studies. If you have any questions, feel free to reach out to me. I hope that I've given you a good basis of an argument that, even, like I said, I don't think you'll hear a lot of critical legal studies want critiques, but I do think that there'll be a lot of different debates where the questions of determinacy of the law will come up, and any research that you do in this particular area will pay off in the long run as you find yourself either going for critiques or debating against critiques, because you'll have knowledge of one of the foundational aspects of a lot of different kinds of critiques. Thank you.